Hello and welcome to the program. I'm Shola Shuyeli. My guest, Senior Advocate of Nigeria, Wahab Shitu, says the lingering issue of conflicting court judgments is a sad commentary on the country's judiciary and again spotlights the need to appoint competent and sound lawyers to the bench. But I began the interview first with his comments on the decision of Justice Abdulmalik Joyce of the Federal High Court stopping the Central Bank of Nigeria from further releasing monthly financial allocations to the Rivers State government.
There is no way one can fault the pronouncement of the Federal High Court in this matter, because those pronouncements are consistent with constitutional provisions. This is a democracy that is governed by the rule of law. And as such, all actions of the executive, the judiciary, and legislature, and all other arms of all democratic institutions must conform with the prescription of the rule of law. We all know that no decision of a House of Assembly can be taken except by 1/3 of all members of the House. That what constitutes a quorum under Section 96 of the Constitution. So for a four-member panel of the Rivers State House of Assembly to sit and pass the 2024 appropriation bill of the House, it clearly is an illegality. And I think what the Rivers State government ought to do is to regularize its operations in line with constitutional provision. We operate a democracy by the rule of law, not a democracy by the rule of the jungle. And here, a distinction should be made, clearly should be drawn from legal, prescription and politics. We are not here discussing politics. We are talking law. No one will be very happy to see that a whole state government is starved of funds. But the Rivers State government without a remedy or an option. Rather than appeal this decision up to the Supreme Court, one will think that they should represent the budget. I mean, the government represent the budget to the Rivers State House of Assembly.
To the full complement.
To the full complement of Rivers State House of Assembly. So that the democracy is not endangered. I mean, democracy dividends and execution of vital government projects are not affected by this. So there's no way you can fault the decision as handed down by the Federal High Court. And if my own view is that even if it is taken up on appeal up to the Supreme Court, we are likely to still come by the same result. So I think the people of Rivers State are entitled to democracy dividends, and they should not be affected by the current political beatbacks going on between contending elements in Rivers State. So, but as far as law is concerned, I think the option is left for the governor is to represent the budget.
Let's move on now to another topical issue. The implication of courts of coordinate jurisdictions giving conflicting judgments. I mean, we've been down this road so many times. Why do you think that this continues to happen? And what would move us forward in terms of reform, that we don't go back to this issue of conflicting court judgments in our polity?
First of all, we all know that conflicting pronouncements by cause of coordinate jurisdiction reflect a sad commentary of the Judas. It creates confusion. It erodes trust in the Judas and raises integrity and credibility issues. It also allows disputes to be prolonged unnecessarily. So I think the Chief Justice of the Federation is addressing that problem. You recall that all the judges who made conflicting pronouncements in the Rivers State matter from reports have been summoned. Yeah. And I think they are likely to get I mean, get their own perspectives for why they arrive at those conflicting decisions. And if it is discovered that any of them, deliver any of those judgments in violation of settled legal principles, appropriate, disciplinary measures will be taken. I particularly frown at it. And I think every decent lawyer ought to frown at it. And the way out is to ensure that those who are appointed to the bench at various levels are people who are highly knowledgeable, people who are also principled, and people who have a track records of making pronouncements without fear or favor. So if there is no evidence of interference in the workings of the judge, and I think we have to sound a note of warning to the political elite to allow our judges to do their jobs, devoid of interference, devoid of undue influence. Because if they don't allow them to do their job the way it should be done, they are not only endangering democracy, they are also endangering the application of the rule of law. And the consequence will be anarchy.
I like the fact that you brought in the executive, the influence of politics, because a lot of the times when we see these conflicting court judgments, it's usually on political cases, and which calls into, as you have rightly said, the interference of politicians in some of these cases. But a lot of people say that we might not get a solution easily if the politicians are still involved in the appointment of our judiciary, because you talked about appointing people that are credible, people that have integrity, people that have a track record into our judiciary. But if we still have the president determining who is appointed as CJN, granted, we follow seniority. But if we still have the president appointing, we still have state governors who would have to sign off then with the legislature before, appointments and confirmation, that we might not get away easily from this issue of conflicting court judgments.
Well, the process can certainly be improved upon. But if you look at the present arrangement of appointing our judges, all the three arms of government in some way are involved. For instance, a governor appoints subject to the recommendation of the NJC, and also subject to the ratification of the various houses of assembly or the Senate in appropriate cases. So this mechanism ensures that all these three arms of government are involved in the appointment process. But the process can be strengthened by ensuring that there is a lot of background checks carried out before these appointments are made. And we should ensure that as much as possible, opportunities are, enlarged to enable as many, legal practitioners qualified as possible to apply. I'm particularly in favor of, and why not appoint from, not just those who rise through the ranks. You can draw a pool of judges from the academia. You can also draw from the body of senior advocates. What should be paramount is integrity, is credibility and knowledge. Because a corrupt judge is a danger to the system. More dangerous is a judge who is also ignorant. By ignorance, I also mean that if you are not up to date with legal principles as they unfold, even if you are brilliant and you know the law, you must constantly research the law in order to be able to apply up-to-date legal principles. So I think it is not just the duty of the judges alone. Even practitioners must ensure that they assist the judges with by citing up-to-date judgments, so that we can enhance the quality of our judgments at various levels.
Do you think that we'll ever see a day where lawyers would be appointed, senior lawyers would be appointed straight to the bench? Because even the judiciary itself is suspicious and does not appear to want to see, they prefer, those who have been queuing
to continue to be elevated rather than see other people come into the bench. So do you think we'll ever get to that time when we would have lawyers come to the bench straight from the bar?
I think the advocacy is on the rise. It's not a question of some people being curious. The administration of justice is our collective enterprise. Judges on the bench will take ownership. Academics will take ownership. Senior lawyers, members of the inner batch will take ownership.
Who should be leading it?
I think it should be, we have the NJC, for instance, National Judicial Council, and all the stakeholders should lead it. I think there should be some kind of conference on this, stakeholders conference, to really debate some of these issues. There is no particular, particular segment that is foolproof in terms of criticisms. If you say appoint judges from only those who rise to the ranks, some might find justification in that. There are some others who also criticize it and have valid reasons to say, okay, it is not in all cases that you find people who are necessarily the best materials, imagine it, eventually, in terms of promotion. And then, so there are the merits and demerits of each of these. But I think what is important is to identify elements who are integrity driven with sound mastery of the law. I recall that some of Idigbe, for instance, Mr. Anthony Idigbe said he had the intention.
Yes, even Olisa Agbakova SAN had interest in going
you
to
can hardly fault these two gentlemen that we have mentioned in terms of knowledge of the law, in terms of integrity. Even the practitioners, those who practice the law, we know ourselves. We know those who many who can be that you can vouch for in terms of integrity, credibility, and knowledge.
Let's round off with a kind of agenda setting for the Chief Justice of Nigeria. She's quite new in that position. And we've talked about conflicting court judgments being one of the issues, and rightly so, she has stepped into it and is addressing it. Senior lawyers will tell you that when they file appeals, they're not even certain of when they will get dates for it to be argued, maybe 3 years, 4 years from now. But, in terms of agenda setting for the CJ and what you think that she can do to fast track justice in the country, what are some of the things that you would advocate?
Well, I will summarize it in terms of agenda setting into two broad themes. In terms of people, it's about the people and about the process. Now, if the CJ and other stakeholders, because the CJ cannot act alone without the cooperation of all other stakeholders, ensure quality in terms of judicial appointments. And that's about people. And when we are talking of quality in terms of judicial appointments, we are also talking of quality in terms of personnel who assist the judges in the dispensation of justice. And quality in terms of members of the bench who advocate before our various courts. It's about the people. So, people who operate in the justice delivery sector. And when I'm saying people, I mean all the stakeholders.
The support staff.
The support staff in the justice delivery system must emphasize integrity. Must emphasize trust. The activities must engender confidence. And they must be ready to support the system in terms of attainment of justice. But apart from the people, the process. Now, we must ensure that the justice delivery system is fast-tracked, avoid elements of delays in the administration of justice, ensure that our rules or procedures in various courts are adhered to strictly, and where we need to make improvements in order to fast-track the process, we should do that. So if the Chief Justice of the Federation, for whom I have a lot of respect and a lot of confidence, a lot of expectations from a lot of people, and I want to just pray that God assists her, His Lordship, in meeting up with those expectations.
And same for the AGF, the Attorney General of the Federation.
Yeah, the Attorney General of the Federation.
Yeah. So a lot of people are expecting a lot of reforms.
The Attorney General of the Federation, Prince Lateef Fagbemi, first-rate lawyer, experienced, and somebody who has seen it all. So for the first time, you have the bench and the bar being spearheaded by elements that many people consider credible and who are ready to work for the judiciary in terms of reforms, in terms of initiatives. So I think a lot of improvements, given this collaboration between these two, the Chief Law Officer of the Federation and the number one Judicial Officer of the Federation, and supported by elements who are also equally credible, willing to assist. We know that the narrative is likely to change. I'm optimistic that it will change for the better.
Thank you very much.